So may I have the next panel, Sharon, welcome. Sharon is a Deputy General Counsel at Intuit. Weber is a partner. Gauri Gokhale, a partner in charge of TMT and intellectual property. And Rakhi Jindal, she is co-head of the Privacy and International Commercial Law Practice Group. It would be, Sharon, it would be good if you can tell a little bit about what all you do, and same thing for my other colleagues, that will be helpful so people can ask some questions if they have, and then know your background much better. So Sharon, can you?
I'm Sharon Matsumura. I'm Deputy General Counsel at Intuit Inc., and I'm one of the in-house counsels of a software technology company that calls Nishit Desai Associates late at night, our time, or maybe late at night their time, saying, help, I need some help, with our India team in Bangalore or Gurgaon or Jaipur, wherever we are. And a lot of times it deals with issues of first impression for us. So if your company is doing business in India, you're going to see a lot of those types of issues, I'm sure, if you haven't already seen them. I handle a lot of global work. I manage a group of transactions, attorneys and contracts managers, and also we provide a lot of marketing, legal support as well at Intuit Inc.
I have to ask them. Yeah, Weber, maybe.
Hello. Yeah. Yeah. This is Weber Parikh. I'm based in Bangalore, and I'm partner for M&A, private equity, and technology. I do a lot of work on technology companies, e-commerce companies, right from doing private equity investment, merger acquisitions, and also all the regulatory and commercial issues which arise in e-commerce company. Thank you.
Hi, this is Gauri. I head the IP practice at Nishit Desai and work substantially on the TMT and pharma. Do a lot of regulatory work as well, advising various regulatory issues in the e-commerce and the SMAC and IoT industry as well.
Okay.
Hi, this is Rakhi Jindal. I co-head the Privacy and the International Commercial Laws practice at Nishit Desai Associates. Before joining the firm, I spent a few years working as an in-house counsel with a telecom company in India. So my primary industry focuses are really IT, e-commerce, and telecom companies.
Yeah.
Thanks.
So thank you so much, I think, for making it. E-commerce and social media have really boomed in India. Various business models are evolving, as Vaibhav mentioned. And then this session, we're going to examine whether laws have evolved to regulate this space enough, whether there are still gray areas, and how companies do risk mitigation. But my first question, I'll ask Gauri, is there a special law in India for online business? Which, what would the laws which apply to physical world would also apply to the online space as well?
Yeah, so I think some of the things Vaibhav has already covered, but let me break it up into 3 segments here when we are talking about any online models. One is the medium related, which is the internet related laws. The second is, the transaction, for example, sale of goods and services, or the content related laws. And the third is the payment related laws. So if you look at the 3 aspects of it, for insofar as the internet as a medium is concerned, we do have Information Technology Act, which came into force in the year 2000, and there was a subsequent amendment in 2008, which in fact made several additions with respect to offenses and cybercrime. So what essentially the Information Technology Act covers is, of course, in relation to online contracts or e-contracts, and Vaibhav probably later is going to deal with that. The other issues, of course, is on the data privacy. So there is a specific provision under the Act which is supported by the rules, which deal with the data privacy issues, which Rakhi may cover later. Cyber crimes I've already mentioned, and the most important thing is the intermediary liabilities, right? Because many of these online platforms are actually the marketplace, or platform where there are peer-to-peer exchanges where the platform actually is only acting as an intermediary. So what are the intermediary liabilities? So in 2011 there were new rules also promulgated on that. The other important aspect, which is the recent Supreme Court judgment, which interestingly said that a law can make a distinction between the online space and the real space. That means there could be a law which specifically deals with the online space, which could be different than in relation to the real world. What it means that if there are certain activities that are happening in the real world, if you just take them to the online world, in that case, in certain peculiar situations where you can distinguish between the real world and the online world, you can have a separate law. And under the Constitution, that will not be held invalid. So with this, this is a fairly recent judgment. With this, we need to see whether the legislatures, pick this up as a point and actually try to do something which is online. There has already been a talk in relation to consumer protection laws. Now, as you know, consumer protection, laws we already have in India of a 1986, act, which was specifically brought into force in addition to the Contract Act, under which in any case consumer could have got protection. But so now there has been a talk that whether for online models there is there is a need to have a separate consumer protection related law. There has only been a talk, no specific law that has been proposed, but let's see how that works. Now, content related, I think the copyright law or the content regulations, there is always a confusion whether for example there is a censorship applicable law which is applicable to television, whether it will apply to the online businesses as well. And we constantly get those queries because the law has yet not developed on that. So what has happened is, as Nishit, you mentioned that basically different business models are evolving. We need to see whether the the existing law applies to that or not. Like in case of MySpace, the judges came to the conclusion that a particular provision of the Copyright Act which talked about infringement, a place where the infringement occurs, the owner of that space also could be held liable, right? So MySpace had that issue in India, and there is a Delhi High Court order in relation to that. So some cases, yes, legislators are coming out with specific laws. Some cases there is existing law being interpreted for the online businesses.
Yep.
So there is always this race between technology and law. And tax, which is Nishit's favorite subject, which we will discuss later. But so this is just a summary that how things are developing, and if we will be discussing some of this in much detail later.
But there is so much in news about regulating the over-the-top OTT applications in India. Rakhi, if I may ask you, what's happening there? What are the OTT applications, and what is the government planning to, regulate?
Sure. So, OTT and connected to OTT net neutrality, these two terms have become like buzzwords in India over the past few months. Everyone's talking about it. The newspapers are stumbling over themselves to write reports, and some people don't know what they're talking about, but everyone's talking about it. So what really is OTT and what's net neutrality? OTT, as you know, as all of you would know, it's basically the provision of any sort of service using the internet as a carriage. Now, what's the debate about OTT? Today, because of the huge proliferation of internet applications, there is a debate that the internet application companies are riding on the bandwidth provided by ISPs and are earning commercial gains, but are not sharing their gains with the ISPs. So there is a debate that whether or not OTT applications should be regulated, whether or not OTT providers should share their revenue with telcos, whether they should be subject to same security and regulatory restrictions as other telecom services. Now, currently it's not regulated. OTT is not regulated in India. What's happening now is that the telecom regulator, the TRAI, has started a consultative process discussing what are the sort of OTT applications, whether they should be regulated, whether they should be lightly regulated, whether you should have a registration scheme, or they should not be regulated at all, or whether you should wait and watch, or whether you should simply impose security restrictions on these sort of services. And the regulators asking for comments from the public, from the stakeholders, from the industry. And I think they've received a few million responses till now. And as a firm, we've also provided our response to the TRI on the consultation paper. You know, to some, our view is that it's too early to sort of think about regulating the OTT industry. It's still in its nascent stages. It depends on the internet. The internet was supposed to be a tool to help innovation and entrepreneurship. So if you regulate it at this stage, you're going to throttle innovation. Besides, we do understand that there are concerns to do with OTT in terms of security, in terms of data privacy, in terms of other concerns. But the view is that you have existing laws in India which can deal with these sort of concerns. Maybe the need is to expand the laws to make the laws more technology neutral, because they were drafted, most of the laws were drafted like 100 years ago. Maybe they're not adequate to deal with newer technologies. But there is a process where you can expand the laws instead of introducing new laws. For instance, if you're talking about security issues in OTT, the counter argument would be that the government already has the power to sort of intercept communications, to ask for records from telecom companies, and also to monitor the traffic on the network. So why do you need a separate security regime? If you're talking about data privacy issues which could be affected by OTT services, the response would be that there is already a data privacy regime in India. I agree that it may not be the best regime, but a regime is there. You could modify the regime, you could amend the regime so that it deals with more, so that it's broader. So right now, the regulators sort of analyzing the comments from the public. Within the next few months, we should expect the formal recommendations of the regulator to the government. A point here, in India, the regulators' recommendations are not binding. They're simply recommendations. The government can choose to take those recommendations or can choose to do something else completely. Now, connected to OTT is the more sort of controversial subject of net neutrality. And what's happening is that net neutrality and OTT is almost being used interchangeably today. But they're not. But they are two different concepts, and it's getting muddled up because of the whole, the media outcry that's happening. The consultative process has, merged the two terms together. So, OTT, like we just discussed, is a method of providing business over the internet. Net neutrality is a principle, it's a philosophy, it's a legal principle that says that network providers cannot discriminate on the basis of content. Now, in India, we do not have formal net neutrality rules as such. I understand that the US is going through its own process of coming up with the bright line tests, and maybe Sharon can talk more about it. That'd be welcome. But what we have in India today is, under the telecom licenses, there are a couple of obligations which licensees have to fulfill. One of them is that they cannot discriminate between subscribers, so telcos cannot discriminate between subscribers. And the second obligation is that they cannot, they have to provide access to all of the content on the internet, except what may be prohibited by law, such as, say, maybe obscene content. Now, in this backdrop, there is, there have been moves in India where a lot of companies have tried to provide sort of innovative models, like Internet.org has come and is attempting to provide broadband access to remote parts of the country, and they're providing sort of zero rating features. There were certain other telcos, like I think Airtel was providing certain zero rating features as part of their plans. Now, there's been a lot of debate that these sort of movements are against net neutrality. And well, what's happening right now is that there's still public debate, but we're still yet to see what the government finally comes up with, what its view is regarding net neutrality and OTT. So that's where we stand with respect to OTT and net neutrality.
Can I add just a couple of lines? One, I think on OTT, this is a very important development. Everybody who wants to do business in India should focus on, because when you have apps, and apps are becoming very common, mobile apps may be covered under OTT, and if they get covered, it can be regulated, and if they're regulated, there may be additional compliance and additional requirement, additional condition which may be followed. So I think this is a time when if we need to get the right policy in place, I think the whole industry needs to get together. I think that was a very important development which Rakhi mentioned about.
Yeah, I think I can see that there is huge interest in net neutrality and all these issues that you spoke about. But again, just going to some basics, Weber, how do companies doing online business approach online documentation or contracts? How does Indian law look at the online contracts, by the way?
Yeah. So going back to the basics, right? A lot of online business, a lot of e-commerce businesses, if you have doing on a website, you will have terms of use, or you will have documents. If you do an app, you will, when they download, you will make sure there are certain conditions you want them to fulfill. The question really is it fine or is it not fine, right? Are we doing something which we can never enforce, or it is just something which is we are following the herd? The answer really is under Indian law, anything which is written on website is considered to be a written document. However, if something needs to be signed, then it needs to be signed using digital signature which is approved in India. And hence, for example, if you're using DocuSign for signing a document, it is not considered to be a valid digital signature in India, unless they go through the process and get it registered in India. Similarly, if you go and press I click or I accept button, that's not considered a signature. However, Indian Contract Act still does not require all contracts to be written and signed. So as long as the law does not require contract to be signed, even online contracts are enforceable in India. What we see is it's important that when you ever go to enforce a contract, there is proper evidence that this particular person has actually signed in that particular contract, and if you are to tomorrow demonstrate that this was done by the same person, you can demonstrate. As long as there is evidence available, you can generally enforce a contract. There are a few other quirks which is there. For example, in India, if you want to enforce any contract, that contract requires a payment of what we call stamp duty, or it's a tax you need to pay on a legal document, before which you cannot enforce a contract. The question really is that if I have an online contract, and since it is in writing, technically speaking, I am required to pay a stamp duty. That particular document needs to be stamped before it can be submitted under the court. But there is no way I have a provision of e-stamp as of now in terms of stamping an electronic document, and that's something which is not yet come. There are moves and there are some thoughts going on in that direction also, but at least today I don't have that facility which I can actually do it. So there may be a question of saying that, this particular document not stamped, and if you want to enforce it, you may have to print it, and you may have to get it stamped, and you may still have to present in a physical form. But those are some of the quirks which we need to live with.
Just to add, when when we introduced the Information Technology Act to recognize the e-documents, we also amended our Indian Evidence Act, where electronic records as evidence could be accepted, and there are certain methods by which you need to prove your electronic records. I thought I should just add that part.
Thank you so much. Sharon, I think they are talking about enforceability of contracts and stuff like that. Are there any specific instances or pain points that you'd like to talk about in the context of e-commerce companies, how typically enforce, and if you could focus your comments on how your deal with the developing markets. How do you deal with the developing markets like India? I'm sure you have a lot of experience in other countries as well.
I thought I'd share 3 examples for our company. Intuit makes software for personal financial management like QuickBooks, and we're very well known here in the US. We also make TurboTax. It's a tax preparation software, and it's SaaS also, and also desktop. But in India, the 3 examples I wanted to share deal more with our SaaS offerings. The first example is a very common business model where we partnered with ICICI Bank, moneycontrol.com in India, and it was leveraging their customers where the ICICI Bank and moneycontrol.com would redirect their customers to our website for personal financial management services online. This is a SaaS model. We used our terms of service, privacy statement. We had a click wrap agreement, and that worked very well. We have another good example that was not e-commerce. It was a free offering, and it was a mobile app for 2 million farmers who spoke Telugu and Gujarati and didn't speak English or write or read English. And for that, our product development team came in and said, well, we want to give some instructions to them, but we want all the instructions on their feature phone, not smartphone, for these 2 million farmers. And it's really to help them be able to get the best prices without having to go to that village that is 40 miles away. They could actually check on their feature phone to see what the prices were for their produce in that region before they took that journey. And it became a very, very popular app, but what we had to do was create an audio click agreement. That was the type of, I guess, e-agreement that we gave them, and it was actually a patent application that I was able to submit through the brainstorming with our engineering team to make everything that we could easy for them to access on their feature phone and not a smartphone. This actually was a service that we sold to another company. It's not one of our core products, but it shows the ability to innovate across organizations. Don't think that innovation is only with your developers and your engineering teams. You should insist on innovation across the board with everybody. And then the last example I have is with our flagship product, QuickBooks Online, and developing an ecosystem in India with small business owners and with accountants. And this is to help them do their accounting, their financial management, things like payroll and payments. If they have, 1 or 2 employees, how can we make all of that easier for them online and remove their pain points so they can do e-commerce and spend time on what they love and not on working on their books and records. And that's something that we have a passion around. That's something that we're trying to build a brand around in India right now. And I would say it's a very, very strong market test for us, and we're building a big ecosystem around that online.
Yeah, thank you, Sharon. I think, as you can see, at the end of the day, there is some rule of law in India, I hope. And I think that's very comforting in spite of all the technological issues that they come up sometimes. But another question, Vaibhav, maybe you can answer that, and that is, how does Indian law look at the concept of intermediaries when dealing with online platforms?
Yeah, thank you. Gauri, I think, mentioned about intermediary regime in India. I do a lot of acquisitions and investments, and when we do diligence, one of the first and most important thing we will do is to see what is the liability of the company which has been acquired, or what is the liability of a company which is being when we're investing. Same way, if we have set up a company in India, the first question they're going to ask is, it's one thing that we make profit or not, but if I have to sit in jail or if I am to get a huge liability, I need to know now before I start a company. So in that spirit, this particular regime of intermediary liability has become very, very critical. What intermediary liability regime or law says that, look, if you are intermediary and you are, basically what it means that you are not initiating any content, you are not controlling any content, and you are doing diligence and following some of the procedures of takedown, then any liability with relating to content which is there on your website or on your pipe, you will not be liable for it under any law. Which means that if I am a website and I have allowed a user to put a particular content and some user has put in a content, then I won't be liable for what that particular user has said. Right? This is something which is similar to what happened in the US in late 90s under DMCA, and that's how the whole liability, intermediate liability regime started. So what is critical here, that if your business, you don't want to be liable for any user content or any information, any content which is either passing through your network or which is put on your website or your app, then there are 3 or 4 critical things you need to keep in mind. First, you should not initiate it. If you are initiating it, that means you are liable for it and you don't have protection of the intermediary liability benefit. Second, you should not be controlling it. And when I mean by controlling it, I would mean that if you have an ability to edit, pick and choose a particular content, that means that you are deciding which content will be passed through your pipe or which content will be on your website or on your app. That means that you are being liable for that particular content. Secondly, if you happen to know, or if there is a knowledge either you get by yourself or somebody draws attention to you that this particular content is illegal, then you have an obligation to take it down in 36 hours. There were a lot of questions on this particular point, saying that what does it mean? If tomorrow unknown person comes and says that, oh, this is a illegal content and I am an affected party, does it mean that I need to take it down so that I can take benefit of intermediary rules, or do I have to make a judgment that whether this person is right or this person is wrong, and whether the content is illegal or content is legal? And that led to a lot of confusion in the Indian market. And people then used to use judgment to say whether I should take it down or I should not take it down. The Supreme Court Act, which Gauri talked about, made it now abundantly clear that unless there is a court order or there is a government notification, that is what leads to an obligation of taking down. But that order or notification doesn't have to specifically be directed to you. It can be a general notification, can be a general order, it can be directed to someone else. But as long as you come to know, or someone draws your attention, the moment your obligation starts, your time starts for taking it down. What is unclear today is, what if tomorrow there's a newspaper report of a particular order? You still are not sure whether that will be considered as a notice for you to take down, and if you don't take down, whether the benefit which you have for intermediary liability or the whether it will be applicable to you or not. So that immunity which is available in the law has to be really carefully looked at so that you can take benefit of it. But if we miss out on some of those points, then you may be liable for the content which is there on your website or app.
No, thank you. Sharon, I would have the same question for you as well. Could you tell us how the courts in the US have been dealing with the issue of intermediary liability?
Sorry. I have a slide that
Sure.
maybe we could show. It shows the basic framework for user-generated content liability. And if you have a website and you're hosting images or a chat room or a social feature or blog, any type of user-generated content where you're not the speaker or publisher, then you want to know the point of view from the laws that pertain to your user-generated content. So in the US, it's very similar to the IT Act, I think. And it allows for a safe harbor or immunity if you're the intermediary, so long as, similar to what Vaibhav said, you're not editing the content. So if you have user-generated content, social features on your website, if you're allowing it to be posted, you should not be liable. If somebody comes to you and says, I think that's defamation, or I think that's false advertising, or I think you should be liable for negligence for allowing that content on your website. You won't be liable, but you should have clear principles on what is allowed and what is not allowed on your website. You can put those rules in your terms of service. You can also have your own principles and policies in your company. And you should also have clear takedown procedures that say when you will take down content. It's not always clear. There's a lot of gray out there where maybe you don't have a court order from a party saying, take down that content. I find it very offensive. You may have to make that judgment call on your own. And there's no liability in the US if you were to take it down because you believe it violates your policies or terms of service. The Digital Millennium Copyright Act in the US limits copyright damages for infringement claims, and a lot of claims that might come in from user-generated content on a website could be trademark claims or copyright claims. Those claims will be reduced in damages if you're able to take down the content promptly. And there are very complex rules around the takedown procedures that you have to comply with under that statute, the DMCA. You see this a lot with regard to the entertainment world and any type of copying of videos and images and things like that. When we talk about the First Amendment in the US, we think free speech, but even in the US, all speech is not protected. So there is speech that you can be liable for. And anything, I guess, IP or criminal violations, you will not have immunity or safe harbor for that content, and you would have to take it down very, very promptly. I have a couple of examples, and do I point it here? Yeah, this one, Craigslist, Craigslist is always in the news. This is one of the earlier cases that had come up, and it was brought by the U.S. State Attorneys General's offices. So various state attorney generals got together and told Craigslist, you're not doing enough to limit and to get rid of prostitution. You need to drop your adult services listings. And there were actually a number of lawsuits that were brought against Craigslist. Craigslist, of course, argued we have immunity under the Communications Decency Act and should not be liable for this content. But in the end, the government stepped in, and I think that's something similar that we're seeing in India as well. This headline, the reason I'm bringing it up, and it's not really recent, is because it really got our executives excited. They couldn't believe they might not be able to go to France. And it's a favorite place for vacations, I know. This was the CEO of Google, who typically, when there are lawsuits brought against a company, if the company doesn't have a presence there, or even if they do, the government might name the executives, the top executives of the company, to draw attention to that case. In this situation, it was a private lawsuit, but the government did take interest in it. And it was a man who had filed a lawsuit because he had used the suggest feature. And anyone who's familiar with Google search knows the suggest feature fills in potential searches that you could search just based on the first word or two that you pop into the search box. In this case, it brought up rapists and Satanists when people put his name in it. And he actually won his case and subjected Google to criminal and civil penalties, which ended up becoming damages that they had to pay. And then the last thing I wanted to show you is just from a practical business perspective, to protect yourselves, your employees, your company, and keep them out of harm's way. I think this applies to where you do business anywhere. If you're doing e-commerce, if you have social features on your site, on your website, and you're hosting these things, even if there is safe harbor or immunity for intermediaries in India or in the US, you still want to have strong, clear principles on how to handle user-generated content. It could still subject your management, your company, to civil and criminal penalties. The government can still take an interpretation that you might not agree with and may say that the information that you're hosting on your website violates legal rules.
Excellent, I think. Oh. Let's see. So, Gauri, what's the liability of online platforms for the user-generated content then?
I think India follows similar pattern, which Sharon mentioned. But one probable, concept which, when we deal with a lot of Indian entrepreneurs, when they are coming up with the new business models where there is a lot of, content. Just to give an example, there are certain platforms where certain blog chains are created where people come and give opinions on various things. It could be about hotels, hospitals, real estate, and the like. So what happens is one thing that they of course can talk about intermediary liability, etc. But sometimes, not knowing how the liabilities will turn, the terms and conditions basically say that all the UGC, the user-generated content, will belong or will be owned by the platform. Now, this is something which you have seen the trend because, your first reaction is that, this is my website, people are putting content on my website, I need to own the content. Now, with ownership may come a liability, right? So if there is a defamation or any of those claims, how the courts will view that on the one hand, you are claiming to be intermediary, and on the other hand, you are trying to claim, ownership of the content, whether it will go, as an argument. So we are in the, what we need to do then, we discuss with the entrepreneurs, we tell them that this is a gray area. And then what we try to do is to say that, okay, you want to use this content, otherwise just take a license. And going back even to, the point that Vaibhav was mentioning on the contract side, assignment of copyright online without signature in any case is not possible. So you are killing two birds, in one, structure, that just take a license of the content. Don't try to claim ownership of the UGC, because with that liability may come. At the same time, you actually may not become the owner because you have not satisfied the requirement under the Copyright Act. So this is a short point I wanted to bring in view of the Indian copyright as well as information technology law.
There is little side point on liability. I wanted to. Okay, so we'll cover it later. Then I'll cover my point. Okay.
Okay. Sharon, anything more you want to add on the?
I think that's a very good point, Gauri. We made a specific change to our standard terms and conditions when we added content clauses and we started hosting community forums. We found that these community forums actually reduced our customer support needs. So our customers or users of our SaaS services could actually talk to each other in the offering and help each other. But we made a definite decision that we don't own the content. So when they come up with ideas on how to resolve something, we don't own that. And I think it's a very common practice now, or a best practice, that you see a lot of SaaS companies following.
Thank you. Raki, there is a regime in India for regulating the privacy concerns and the collection and transfer of personal data. Could you tell us a little bit about how this regime affects the cross-border e-commerce transactions?
Sure. So there are two things, right? One is privacy.
Can you be a little louder and?
Yeah. Is this better? Yeah.
Yeah.
So there are two things, right? One is privacy and the other is data protection. When it comes to privacy, we don't have a specific law in India dealing with privacy. We have the constitutional provision which says that the right to life equals right to privacy, but that's again available against states, so it's not relevant to our discussion today. When it comes to data protection, again, for the longest time, India did not have a specific data protection law. What we have today we do have a law today. It's part of the Information Technology Act, and it relates to the collection and the storage and the processing and the transfer of what's termed as sensitive information, sensitive personal information. Now, this law is fairly new. It's about 2 or 3 years old, and it's still limited in scope, so it applies to very few items of information, and some of the relevant items would be bank account information, passwords, and in the realm of e-commerce and applications, sometimes Webu was talking about healthcare applications which record your vital statistics, which record your health information on apps and can be recorded and can be transmitted to your doctors or your hospitals. So even in that context, healthcare information may be relevant when it comes to sensitive information. Now, what really is the law about data protection in India, and how does it affect e-commerce and online businesses? The Indian data protection law has a very location-specific application. So any of the activities of collection of the data or storage of the data or processing of the data have to take place in India for the law to apply, or there has to be transfer of the data to or from India. So in this context, if you have a website that's managed outside of India totally, but it's directed towards India, and you have Indian users, and those Indian users are perhaps giving their passwords and their bank account information to the website, but all of it is directly going outside of India, in all likelihood, the data protection laws would not apply to the website. However, if there is a presence in India, or if any of the activities, say you have a server in India which is sort of storing the data, or you have some collection activity that's taking place in data, or you have a business processing unit which is sort of processing the data in India at a later stage, the Indian law will start applying. And what are some of the most important compliances under the law, because this is more of a compliance law? One is, of course, consent for collection and consent for how you're going to use the information. The consent has to be in writing, so it can't be oral consent. And writing, we discussed, it could also be electronic forms, it could be through email, it could be through your click accept agreements. And I think some of the other important aspects of the data collection law is that every time the data has to go outside of India, again, you need consent. And the entity that's transferring the data has to ensure that the transferee entity complies with at least the minimum levels of data protection which Indian law requires. And then you have other principles of having a privacy policy which is going to set out your security measures in place, which is going to set out why you're collecting the data, what you're going to do with the data, where you're going to store the data, where you're going to transfer the data. And the law also prescribes certain security mechanisms which you need to implement and maintain in order to protect the data. So that's about it.
So, but what happens if there's a breach of, a law, okay? What happens when an online platform or e-commerce company is held liable? What's the liability of officers, directors of e-commerce company? Gauri, would you like to pick up that, or Rakhi?
Yeah, sure. So just to add to, before I get into this particular question, just to add to what Rakhi said, that on the data protection law in India, we do not have a notice requirement of breach. So there is no breach notice. Plus, we do not have a regulator as such to, whom there is the requirement to notify any, compliances, etc. So it's a self-compliance. The only liability that arises is when you have negligent in enforcing your security practices, which leads to wrongful loss or wrongful, loss to the user. So the liability is more on the civil side when it comes to this particular requirement. It becomes more on the criminal side if there is intentional disclosure of the data. So there is a difference made between negligence and intentional disclosure. Now coming to the liability, and probably Weber may want to add a few points later, but the director's liability or the officers in charge of the company. So most of the Indian laws, the way they basically provide the liability on the directors or the persons in charge, they don't necessarily use the word directors, is if there has been any breach, then the assumption is that the person in charge or who has been responsible for the company is held liable. This is an assumption. Now, if at all there is a charge imposed or alleged against such individuals, in that case, what they need to prove that it happened without their knowledge or that they had taken an appropriate due diligence. Now, what happens is there are some offenses in the Indian context which is called as cognizable or non-cognizable. So sometimes these are the bail. That means if there is a potential of arrest and there is a complaint filed, then the directors can be directly arrested in some cases. So there are, since we are talking about gamut of laws here, there are criminal laws under the Information Technology Act, Indian Penal Code, Copyright Act. There are variety of laws. So what one needs to examine is whether there is a liability where the directors can be arrested directly or the persons in charge can be arrested directly. And if such a situation arises, what we have something called anticipatory bail. That means in anticipation of arrest, you would go and try to basically get a kind of a waiver from arrest, what we call as bail in India. This becomes also critical slightly in a different context. Under the Companies Act now, the new Companies Act that we have in India, the directors are required to basically give a certification that the company is in compliance with all the laws. And in this context, what we have begun to see, and especially when you have complex business models, and we have seen that e-commerce businesses are getting more and more complex with various sort of delivery models, various payment models, various goods and services that they deal with. So whether or not there has been a full compliance of all the applicable laws, there is a requirement to issue a certificate. So a lot of, from a risk mitigation perspective, now a lot of companies have, started looking at audit, which is a self-audit to see whether or not I'm in compliance. So one is, the liability coming on, and we have seen, in fact, in case, when eBay acquired Bazian yesterday, we briefly discussed this. There was a content that was posted, unknown to the directors on the website, and there was a request for takedown. There was that time we frankly did not have these regulations of takedown, etc. But there in fact there was an arrest of the director. And in the recent past also we have seen some of the e-commerce websites facing some issues because certain products should not have been displayed on the website for delivery. For example, there are certain prohibited items where, in such a case also some relevant regulators may take action. So it is, everything appears nice in the virtual world, but there is a real world also out there where the liabilities are going to come. So, one has to be really mindful and do all your audits and, regular. And this cannot be just one-time audit. In my view, this has to be a periodic audit, which one has to undertake.
I'll just add, Gauri mentioned about the eBay case. I think it became quite well known in the world at that point of time when the CEO was arrested and put in jail for a video clip which was obscene and which was sold by someone on eBay. The law at that point of time, we had intermediary immunity protection, but that intermediary immunity protection only applicable for any act done under the IT Act, because that law was under IT Act. And because this was not just violation of IT Act, but it's also violation of Indian Penal Code and a lot of other laws, he couldn't get benefit of the immunity under that laws. Post-which there was a change in 2008 where even other laws were brought into ambit of the immunity. Today, I think you can take a benefit of it. But having said it, I think there are 2 or 3 critical points which I wanted to make. First point is that generally when you get arrested, I've seen that there is a tendency where the arrest will come on Friday evening, so that you have no choice but to wait for 2 days before you can go and get bail, and that's something which ends up any person spending 48 hours in a jail, not a very good prospect. So if at all, if you're doing a business in India, and if at all there is a concern, or you have someone who's a director in India, and your associate who are concerned, you need to take immediate help of a lawyer, so that preventive action can be taken, what Gauri mentioned. Second point which I wanted to mention with respect to on the liability side is under Indian law, if there is a violation of copyright, and if there is an intentional violation of copyright, it's also a criminal offense. And especially when it leads to, for example, take films, for example, the film piracy, or from broadcasting perspective, for music, there are a lot of websites which used to go and permit music downloads of pirated songs or of films, and those can, if it was knowingly done, if it was a mens rea, those can also be considered to be criminal offense, and a very strong tool used by the copyright owners against such websites. I just wanted to.
Thank you so much. If there is a question, we can take. But one other thing I just wanted to possibly do was, since it's not a very large group, if each one of you can give us little idea as to what are you doing, and maybe we can look at if there are anything that we can understand. So can we start from the end? If you can just introduce yourself and what business you're involved in and what you've been doing. Sorry. Okay. So it will be nice to get introduced. We can possibly see what comment any of the speakers would have, or at least know each other, and then.
There you go. Hi there. I'm Craig Werbellion. I'm with the law firm Sullivan & Cromwell. Okay. Thanks very much for hosting this event. It's been really interesting for me. I'm interested, not from any personal experience at this point, but I'm interested in general in any of the biggest concerns that could come up in e-commerce companies in connection with capital markets transactions. So any personal experiences that you've had finding trends and the types of diligence issues that would come up with respect to the issues that we're discussing in the deals that you've done are especially interesting for me. I don't personally have experiences to share at this point, though.
No problem.
Thanks very much.
Okay.
You want to take the questions now? With long.
What I thought, you can take all the introductions, so we have understanding, and then you can make comment on each one quickly.
But let me just answer his question quickly, so that it doesn't look the contest. Typical issues when you are releasing an e-commerce company, and we need to keep in mind, are the one which is on the foreign direct investment, which I just alluded in the introduction time. Those are very critical. Secondly are the intellectual property and data protection issues. The third is the liability, especially on the product liability side. I think I would look at these three as critical. Rest, I think.
Yeah. Please.
Great. My name is Kevin Penzine. I'm with a company called Citco Corporate Services. We assist with offshore holding structures a lot of the times inbound into India through our presence in Mauritius and Singapore. So I'm more interested in the sort of the tax planning side of inbound FDI.
Okay.
My name is Sam Lester of L&M, and we're considering moving our mobile data platform into India. So here to find out more information from the legal perspective.
Thank you. Yeah.
I'm Amanda Athanasiou, and I'm actually a reporter with Tax Analysts, and I'm on the international team, and we do daily and weekly publications, and we try to keep abreast of everything going on throughout the world, and India in particular has been a really interesting source of news lately, so I'm here to do my homework.
I'm Jay Carmarker. We run an early stage company in e-commerce and e-games, and we're trying to integrate the two. And we're trying to look at what opportunities there might be in India, both from a development side as well as from deployment.
Thank you. Ken?
Ken Silverman. I head North America for a company called Sonam S4 Consulting. We bring corporations, universities, and nonprofits into India. We recently brought an e-commerce company into India. So one of my questions is relative, even broadly, what is the difference, or are there differences, regulations, laws, and so on, for U.S.-owned companies coming into India and setting up e-commerce? And then a subset of that, are there any differences relative to such an American company if it's owned by non-resident Indians or persons of Indian origin?
Okay, quickly, I think in most businesses, India is open to 100% foreign investment except B2C. I think that's the most important thing, right, Weber?
Yeah, that's correct. And also, if you are a non-resident Indian, then there are certain additional conditionalities or additional regulations apply at the time of exit if you are buying from them or if non-resident Indian is selling. But other than exchange control regulations, FDI regulation that Nishan mentioned, there is no prohibition or no difference between a U.S. company investing.
Yeah. And as far as outbound is concerned, there are two categories. For individuals, up to $250,000 they can invest abroad. And as far as Indian companies are concerned, they can invest 4 times its net worth to acquire the companies outside. Those are the major two quick answers to the whole thing. Okay.
Just to clarify, I think there is a possibility that foreign companies who are into e-commerce or any other distribution directly have users in India. So there are situations where you need not have a physical presence. You could do your business sitting outside and having users in India. In those situations, we typically come across exchange control regulations when it comes to remittance of the funds from Indian users to foreign foreign platforms. Gaming is one good example where FDI as such is not permitted, but at the same time remittance from India for the purpose of playing on any foreign gambling websites is also not permitted. So one has to take into account those regulations even if you're operating from offshore directly into India. The other thing is, there is a new Companies Act which has come in, which discusses about foreign company and e-commerce companies which may not have a physical presence in India, but may be doing business, and there is slightly complex definition. I'm not getting into that. And there are rules also which clarify that definition, but one has to be mindful of that compliance as well, that if you're, get into that sort of definition, even if you do not have a physical presence, there may be local compliance required under the Companies Act.
Yeah.
My name is Kevin Lucas. I'm the general counsel at a e-commerce B2C retailer of art reproductions. So for reasons that have been stated, I'm interested in the topics today. And our company is looking more closely at the Indian market, and thanks for the discussion.
Whether you'll be able to deal with this question. Let us quickly go through, and I think those specific things we can deal with later. Yeah. Can I have, yeah.
Thanks. I'm Thea Apple. I work for the U.S. India Business Council, and Nishit Desai Associates is a longtime member of ours, as well as many of the other companies in the room. But it's wonderful to be here, and thank you so much to all the panelists.
Yeah. Can we have your introduction? Yeah.
I am S.L. Srinivasalu. from a company called KESD, which is an online learning company. We are based in San Diego, but our development center is in Bangalore. We own our content. We do not do any custom content development or platform. We have a catalog which we license to financial institutions around the world. Of late, large IT companies in India have taken interest and want to license our content. We develop all our content in Bangalore. We host it in Santa Clara, and we serve clients.
Thank you.
Both B2C and B2B.
Yeah, e-learning is an important part of India's, activity at this point in time. And next one.
Hi, my name is Vartika Jain. I used to practice M&A and private equity advisory in India. And now I'm going to pursue my graduate studies in law at Berkeley Law, in focusing mainly on surveillance laws.
Oh, thank you. Sandhya, maybe?
Hello, everyone. I'm Sandhya Sharma from New Delhi. I come from a company that needs no introduction. I think all the panelists talked about eBay. And we're working in India for last 10 years. I think one comment that I have that I think we really need to have, I think the eBay Bazi case where the CEO was arrested. So I think that actually led to the IT Act amendments. And finally, we have an intermediary liability clause under Section 79. So I think now is the time that we need to kind of rev up and do some kind of an education to the law enforcement, where I think there is still a big difference between how an IPC or an IT Act, is kind of, these people are not sure. So I think a law enforcement education and outreach is very much required in India. Thank you.
Yeah. Can we have some?
Hi, I'm Alan Safahi. I'm founder and CEO of ZipZap. We are a San Francisco-based startup. We are launching a mobile money transfer app for migrant workers to send money home.
Oh.
We are initially launching it in Canada because it was easier to get licensed there than in the US. In the US, you have to get licensed in 50 different states, whereas in Canada, you just need one national license, which we have obtained already. So we're launching in June. We use a combination of traditional payment railways like banks and digital currencies like Bitcoin and Ripple. I saw the word Bitcoin outside, that's why I came in. I don't know if you've already talked about it or not, but I'd love to learn more about whether or not Bitcoin, I know it's legal, but it seems like it's gray area in India.
Yeah, I'll be happy to deal with that in this next one.
Okay.
Quickly, you can be a little louder because we have to beat the noise outside. The lady.
Glory Vials from Intuit, and I work for Sharon Matsumura and supporting her in all the work.
Thank you.
Yeah.
I'm John Schlosser with the Albright Stonebridge Group, a Washington-based international consulting firm. I'm active in the India practice and recently relocated to the West Coast. I remember we had a very large IT company client at the time that the eBay executive's arrest took place. It sent sort of shudders of apprehension through that community, and so we try to monitor, I think, the sort of the confluence of political factors and business factors in the e-commerce area. And thank you for putting on this forum.
So nice of you. Quick.
Hi, I'm CK Singla with MedDirect. We are online healthcare provider. We just started looking to start operations in India. And a lot of the laws that have been spoken about are quite relevant to us, both from, the ownership structure and how to structure the company in the right way.
Thank you.
Yeah.
Dave, of course.
David Conrad. I'm actually, despite being a technical geek, I am actually quite interested in the legal implications, particularly in the context of the resources that ICANN deals with, and things like whether or not the export of contact data for domain name registrations violates any data protection laws within India and that sort of thing.
Thank you. I think you were here yesterday, but it would be nice to have a little introduction from both of you. Little introduction, very quickly, and I think one more, and then we close for the break. But we'll definitely deal with other questions. Okay. No? No, anything, what are you doing? Maybe 1 minute snapshot, half a second, 30 seconds.
I'm Linda Brownstein. I'm sitting next to Neil Brownstein. We're co-founders of Footprint Ventures, which is a cross-border venture capital fund in Bangalore and here in Silicon Valley. And I just want to thank all the people from Nishit Desai, including Nishit, for putting on this terrific forum.
So nice.
Most generous.
Thank you.
Thanks. I'm another one of those wandering people. I just outside saw Bitcoin and came in. I'm a senior director with Visa, so working in innovation and strategic partnerships.
Thank you. You want to introduce anybody else? That's all? You.